A man enduring tragedy, watching his wife die from a severe allergic reaction at Disney World's Epcot Park last year. She was a medical doctor. They told and confirmed her allergies with restaurant staff. She self-administered an EpiPen to no avail. And now, as this man looks to bring the wrongful death case in front of a jury, Disney lawyers are pushing back hard. Last year, the man, his wife, and her mother ate at an Irish pub in Disney Springs. It's a part of the Walt Disney World Resort in Florida. The lawsuit says they were assured the food would be safe after disclosing her severe allergies, but she died from anaphylaxis, the medical examiner finding both high levels of dairy and nuts in her system. Disney says the husband signed up for a Disney Plus account in 2019. And in the fine print, he agreed to waive his right to a jury trial, instead favoring arbitration. The family's lawyer saying, in part, Walt Disney Parks and Resort is explicitly seeking to bar its 150 million Disney Plus subscribers from ever prosecuting a wrongful death case against it in front of a jury, even if the case facts have nothing to do with Disney Plus. The family goes on to call Disney's claim unreasonable and unfair. Well, Disney is responding by saying, given that the restaurant is neither owned nor operated by Disney, we are merely defending ourselves against the plaintiff's attorney's attempt to include us in their lawsuit against the restaurant. Earlier tonight, I spoke with defense attorney Mark Reichel about Disney's legal loophole here. Take a listen to our conversation. Mark, bottom line, if any of us have ever signed up for a free trial for Disney Plus or signed up for Disney Plus proper, are we waiving all kinds of rights that we don't know about?
No, the bottom line is this will be thrown, that defense will be thrown out. It has to be closely related to the service you're accepting. So you say, I accept all the terms and so forth. They really originally were drafted so that when there were these class action suits, let's say Disney Plus charged you $7.99 a month or whatever it was. And later on, 3 years later, we find out that they really were charging other people less and you should have been included. And a class action comes in. That goes before a jury. It could be giant award. So these little agreements that are in there that you accept are to get arbitration for what you're purchasing or what you're getting from them that day. It doesn't apply to everything Disney does.
Yeah, I appreciate that. And you know, Mark, we're seeing this family asking for 50 grand plus damages for pain and suffering, as well as medical expenses. Why does it matter to go in front of a jury for a case like this?
Usually juries actually will be more sympathetic and will give more money. Arbitration kind of has limits on how much money you can actually get out of it. And so an arbitration is a panel of judges, 1 to 3 judges, will hear what you have to say, you know, and they're lawyers primarily, and they'll issue awards and so forth. But arbitration really keeps the awards down. Whereas you go in front of a jury, you could get a runaway jury and get a really high award.
Yeah.
That's why firms always want arbitration.
What would you expect in a case like this? I mean, what are the details of this case? What did this man and this woman who watched her daughter die, what did they endure?
Well, you can't imagine what's that like, especially they were so proactive. They asked several times, we need to know if there's any of these specific allergens in this food. They were assured several times over. It was a restaurant that is billed and advertised to bring you in for the special reason that there's no fruit allergens in their food. And then to just, you know, go out that way to die after you just had dinner with the family at a theme park, there's nothing worse than that.